Alex here with part 195 of the My Docket series on child custody and visitation. As in my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. Now we're going into my filing of a motion seeking leave of the court to set my son's vision appointment. If you remember correctly, there was a discussion at the very end of the child custody hearing where I recall the judge leaning towards giving me the right to set and attend certain appointments. I think it was all the appointments. And then my ex brought up the fact that I was willing to consent to her setting the vision appointments. This is one of the problems with exploiting good faith. Take a look at the video on the topic exploiting good faith. So she exploited my good faith. The judge agreed. The judge gave her the right to set the vision appointments, and then my ex just decided not to set them. So I ended up having to file a motion asking the court for permission to set them myself. Now, I assumed that this would be going forward. Unfortunately, the judge only orders it for the next vision appointment that's coming up. So I end up having to file. And not only that, it's also a problem because she ends up saying that I still have to set the appointment in Reno, even though I don't live in Reno, which I don't understand. I mean, let's just go through the through the judge's order and then we can laugh at it. But so she does ultimately give me the right to set that vision appointment, but she says that I have to set it in Reno. So I have to file another motion, which then gives me sole legal custody on everything, including the vision appointments. My mindset, despite all of this nonsense, was actually pretty good. I know that in the last video, I totally lambasted the judge over her violation of my ex's due process rights, but that's all hindsight analysis. That's all just me saying, now that I'm out of it and I'm analyzing this with a more objective eye, this is obviously inappropriate, and it really tells me a lot about that judge. But at the time, way back then, of course, my mindset would be very positive because that's peace of mind. You're worrying what's going to happen to your child when he's sent on a visit when you don't know where your ex lives. And now you don't have to worry about that anymore. You get an order saying that her in-person visitation is suspended until she gives her residential address. So, of course, at the time, I felt great. And when I was filing this motion, maybe it was a little bit annoying that I would have to do it, but I felt like, okay, the judge is waking up now. She's paying attention finally. And so I felt like I was going to, have an easier time now taking care of my son. Of course, an easier time means after a few more filings, but for the most part, she doesn't deny anything else that's within the boundaries of child custody. I think there are still some issues later on with execution and asset seizure where I have problems with this judge. In fact, I'm pretty sure I do, but we'll wait until I get to that point in the series. I think for now, we can go ahead and get straight into what I have filed. Here we have my motion seeking leave of the court to set vision appointment. Guys, I don't know if this is really... See, sometimes when you're a non-attorney, I guess attorneys might do something like this too, but this kind of just goes back to, is this even really supposed to be an available mechanism? I think the video where I talk about this is gray areas, where I aggressively address the issue of trying to close off all of the possible gray areas versus just modifying custody. Maybe this isn't really, another video that'll help a lot is behavioral orders. Again, this doesn't really fit into that category, but it just goes into the whole bucket of things that you're trying to do to avoid changing custody, but at the same time take care of your child. And in both of those two different videos, the behavioral orders video and the gray areas video, I deal with my opinion, which has changed, um, to just saying if your ex isn't doing what she's supposed to do, that should be a modification of custody. It's like, why be nice and ask for a half step that doesn't quite change custody but lets you fix a problem, when in reality all you're doing is putting your ex's needs over your child's, and that goes into best interest of the parent. So in hindsight, I think I should have just filed a motion to modify legal custody just straight away. I mean, this is basis enough. I mean, it's one thing if somebody isn't doing something because they have a reason and you both disagree as to what the reason is, and you need the judge to step in and say, okay, one of you's right, one of you's wrong. But it's another thing to just plain not care. In fact, she didn't care enough to set the appointment, but she cared enough to ask the judge at a hearing to have this right. She cared enough to speak out and say, Your Honor, he said I can have vision appointments. Can you let me have what he said I can have? And then, of course, the judge, without even checking with me, says, oh, okay, well, that sounds good. So all that work to ask for something, to have something, but then not do anything with it, that just goes to the whole high conflict mentality, which is the conflict itself is the point of everything. The actual substance of what you're asking for and of what you're trying to do doesn't matter. The whole, the whole thing about the child and setting the appointment, none of that means anything. It's the conflict. It's the ability to say, hey, I want this. Thanks for letting me have it. Now I'm not going to do anything with it, but thanks. It feels good to have it. And then I can tell everybody else that I have this now, even though I'm not going to do anything with it. So all of those things being said, I think I should have just filed a motion to modify legal custody instead of bothering to do this. But that's okay. We're going to still go through what I did, and it gets granted anyway with those weird limitations that I mentioned earlier, where she grants the motion but says I have to set the appointment in Reno. Okay, so standard introductory paragraph. I'm identifying myself to the court as the petitioner. I'm indicating that I do not have an attorney, so I'm appearing in proper person. And then I'm filing a motion to set a vision appointment. Memorandum of Points and Authorities. We have a brief summary here where I outline for the court that I am the natural father. My ex is the natural mother. We share a child of age 9. I have primary physical custody. My ex has visitation rights only, and we share joint legal custody. Factual background. On June 29th, the court pronounced from the bench that my ex would schedule the child's vision appointments in Reno. On November 9th, I asked my ex if she was going to schedule the appointment. Exhibit 1. On November 13th, the court entered order following June 29, 2015 hearing. The order reduced in writing a parenting plan, scheduling specific visits, placing upon my ex the responsibility to set the visitation appointments. I think I meant to say vision appointments, so that's probably a typo. Let's take a look here. Yeah, Monica shall make all arrangements with our son's regular vision-related appointments with his eye doctor. Okay, November 20th, my ex failed to exercise visitation. November 27th, my ex exercised her Thanksgiving visitation. December 18th, my ex failed to exercise her visitation. January 22nd, the court ordered that my ex shall have, or that, wait, what? Okay, my ex shall have the sole right to attend visits with the child's vision providers. Okay, so this omnibus motion here, this takes care, okay, I know what's happening here. So I had the right to set all the appointments except vision. She had the right to set vision appointments, but we were still both allowed to go to each other's appointments. Then this order regarding omnibus motion was entered, and that kept the appointments the same, but I had the sole right to attend the appointments that I scheduled, and then my ex had the sole right to attend that vision appointment. To date, my child is overdue for the vision examination and has not had his vision appointments scheduled, and that's supported by a declaration of Dr. Terrance Cochrane. Really good move on me to get that declaration from the eye doctor. When you're doing stuff with an attorney, oftentimes the judge will take your word for it. When you're representing yourself, it helps to have these little extras. So we're going to go over that in a second. Legal analysis, vision appointment. The court recognized and encouraged my utilization of the civil process. The court admonished me for taking quote-unquote unilateral action, even in the context of an ex parte filing. And the reason I'm saying even in the context of an ex parte filing is because that's not unilateral action. Unilateral action is where you just do it. I filed something. That's not unilateral action because the judge entered an order denying it, though she later on changed it when she entered the order regarding omnibus motion. So all of this chaos behind us. In Nevada, as in other states, the child's best interest is paramount concern to the court, specifically includes physical, developmental, emotional needs. The child's optometrist in Reno has declared under penalty of perjury that it is professional opinion that the child is overdue for a vision examination. In this case, the lapse in time for the child's vision exam is not too great. Had my ex indicated that it was her intention to schedule the appointment, the motion would not be before the court today. The whole issue at this point is not merely the fact that the child is late for his appointment, but further that I have no idea if or when my ex intends to schedule an appointment. And then I go into this tremendous history of all of these messages that she has not opened. And we're going to go ahead and go into those. I'm sure they're going to be attached. So next we have me now seeking leave of the court to schedule the child's vision appointment, and that I'm understanding that this can be confusing to the court as it was my request to delegate the duty to my ex. However, I anticipated that my ex would actually schedule the appointments and take the child to them. I didn't anticipate that she was just going to not care. So I'm indicating here that I'll withdraw the motion if my ex schedules the vision appointment. Alternatively, she can communicate to me that she's at the very least planning to schedule the appointment. Court's order should also distinguish whether I have leave to set the vision appointment just one time or if the parenting plan is permanently being modified. Mediation. You guys have seen this before. This paragraph here is what I use to get out of mediation. If you want to learn more why I oppose mediation ever since the third one failed, watch my video on the topic mediation and settlement. Conclusion. I hereby request that the court grant me leave to schedule the child's upcoming vision appointment or in the alternative modify the existing parenting plan. Verification. Since I'm stating here under penalty of perjury that all the facts alleged are true and correct, certificate of Rule 5 service indicating this document is mailed to my ex. Motion opposition notice indicating I don't have to pay a filing fee. List of exhibits. So we've got the Our Family Wizard message and we've got the declaration of Dr. Terrance Cochrane. Number 1. Are you going to schedule his appointment soon? No reply to this. Exhibit 2. Declaration of Dr. Terrance Cochrane. You know what? The next document is dedicated to just this. I don't know why I attached it as an exhibit and filed it as a separate document. So we'll just take advantage of the fact that it's its own unique, separately filed document, and we'll go over it at that time. It's the next one in the list, actually, so we'll see it very shortly. There it is. Next document is the declaration of Dr. Terrance Cochrane, filed separately, so I figured this is the best time to go through it. He is indicating the standard boilerplate, which is he's over the age of 18, not a party to the action, that he's never been convicted of a felony, that he's not declared mentally incompetent, and then we get into the actual meat of the declaration. By the way, guys, if you want to know more about the difference between a declaration and an affidavit, watch my video on the topic, declarations/affidavits. I go into the Nevada statute that allows you to use a declaration in lieu of an affidavit. That he's a graduate of the Ohio State University College of Optometry and has been practicing in Reno for over 26 years. That he's completed a postgraduate program in ocular therapeutics at the University of the Houston College of Optometry and is board certified in the treatment and management of ocular disease. That he owns and operates Cochrane Family Eye Care. That our son is his patient and has been his patient since 2009. That the last examination of our son occurred 11/21/2014, and that it is his professional opinion that our son is overdue for his examination as of 11/21/2015, and that he is not related to me nor my ex, and that it is his understanding that both myself and my ex are the natural parents of the child. Okay, he signs it. I sign the affirmation, which states that there's no social security number attached to this document. We have Rule 5 certificate of service indicating this document was mailed to my ex's attorney. This must have been, should have been mailed to my ex, unless at the time she still had her attorney, which I don't think so. So maybe this was an erroneous certificate of service. But in any event, I'm not sure that it matters. Can't remember now. You can check out the timeline sometime. Somebody post down in the comments below if at this point in time, this declaration, well, actually it wouldn't matter because the motion had the correct certificate of service and the motion contained the certificate of service with the exhibit of, so it doesn't matter anyway. So this declaration was included as exhibit 2 to that motion anyway, which was sent to my ex. Next document, settlement proposal for expedient resolution. I like this. I remember thinking this judge is not going to want to hold a hearing. This judge is not going to want to hold a hearing again. She's sick and tired of me. And if I give her the option to skip a hearing, she will take it. And that's exactly what I did with this supplemental proposal. So I'm letting the judge know that under DCR 13.3, she can resolve a matter without a hearing, that the purpose of the supplement is to obviate the need for an order to show cause by focusing on the alternative relief requested in my motion for order to show cause. And I am taking advantage of the fact that I asked for alternative relief, and I am urging the court to just go ahead and go along with the alternative relief requested instead of trying to have my ex held in contempt of court. A lot of people might say, why are you doing that? She deserves to be thrown in jail. The court doesn't care about who deserves what. The court is a machine. Watch my video on the topic, the machine. All I want is a court order that's going to protect our son. If I have no choice but to have my ex thrown in jail, then that's the maneuver I'm going to make. But if I can avoid that, then I will do that as long as it solves the problem, as long as it ends the conflict. A lot of times my ex would try and say, he's an evil man, he's trying to throw me in jail, blah, blah, blah. But there were many opportunities where I could have said, you know what, you're not following orders, I'm going to push this contempt thing. Contempt is what I use when I have no other thing that I can use. When I have something else that I can use instead that will end the conflict, that I especially know the court's going to want, because most judges in family court do not want to use contempt. They hate it. Watch my video on the topic family court contempt, where I interviewed attorney Eric Johnson from Utah on the topic. That's me right here taking advantage of the psychology of the court, working around the family court's dysfunction to solve a problem that both saves us time and stress. So, child support. I am requesting, let's see here, that the order relieve my ex of her duty to provide the child with medical, vision, dental benefits, and that in relieving my ex of the obligation, of which she has been in non-compliance since November 2015, it would necessarily eliminate the $89.67 monthly deviation in her favor. So I'm trying to say she's in violation, she's in contempt of court for not providing insurance. My solution is take away the obligation. Make it so she's no longer ordered to provide insurance, but also take away the deviation. So she's getting an $89 discount on the child support. She should lose her discount, but she should also lose the obligation to support him with those benefits. Just like that, she's no longer in contempt. We've solved the problem. Moving on. The court has already recognized my ex's failure to share medical, vision, and dental benefits information anyway. The court has already ordered my ex to pay half of the premiums that I pay for anyway. So what it's going to come down to is just eliminating that deviation that she had in her favor. Respondent's current monthly child support obligation is $471.57. By eliminating the deviation and imposing my deviation, the court would adjust respondent's child support to $649.09 effective January 1st. Done. Outstanding judgment on it. If you guys can't tell, the court takes this option. As soon as I open this door for the court immediately agrees. Just like that, resolves all the motions. No order to show cause, no contempt nonsense. Done. So let's go ahead and finish going through this. Outstanding judgment on arrearages. My ex has failed to pay her $50 payments. I'm requesting the court grant a portion of alternative relief requested. The district attorney has already instituted enforcement proceedings against my ex. And the court should order that prospectively the monthly payment plan as referenced in the previous orders is vacated in its entirety, and that the district attorney may proceed and use all available remedies to seize assets for the judgment on arrearages as well. Failure to return the child's clothing at exchanges. My ex's failure to return the child's clothing at exchanges. I'm requesting the court grant a portion of the alternative relief requested here as well. I would like the order to prospectively state that I no longer have to provide clothing at exchanges, and instead my ex would be entitled to a $25 monthly child support deviation in her favor, and that she can retain any clothing she purchases, thus resolving the portion of the order to show cause seeking to hold her in contempt for failing to return the clothing. So this is me saying, I told you so. Let's go back to not exchanging clothing, just like Judge Weller ordered, so that this problem can go away again for the second time. The judge actually agrees to this. So at the hearing, she had this look on her face like, I'm not going to order that. That clothing is his. Now she's changed her tune, because now she sees what high conflict child custody looks like. It's an animal that most of these judges have never seen before. They think it's just two people bickering, but they don't understand that two ordinary people who are bickering can eventually get over that. They can move on. When somebody has high conflict child custody issues, it's a mental health issue. It's an insane level of obsession. It's like a mind-affecting compulsion that they have to do all of the crazy things that they do. I think I cover this in more detail in the video titled High Conflict Incompetence. Anyway, let's move on. Communication with father through child. I've set forth no alternative relief requested on this point. However, my ex has not attempted telephonic communication for months. Therefore, I'm going to go ahead and just let this one go, and I can bring it back later on. Conclusion. The proposal provides a mechanism, DCR 13.3, and multiple solutions as outlined above, by which to resolve the pending motion without a hearing. Such a resolution would be an efficient preservation of judicial resources. Um, and I wouldn't have been able to do this, guys, if I didn't ask for the alternative relief in that motion for order to show cause. So if it was just a motion for order to show cause, and I was asking for this now out of the blue, this would be a violation of my ex's due process rights. But everything that I'm requesting in this document, I already requested in that motion. So she has had notice of that. She hasn't responded. And all I'm doing with this document is I'm telling the court, hey, you know what? Why don't we just skip this hearing? Just give me all the alternative relief that I'm requesting. Forget the motion for order to show cause. Let's just move on. And the judge agrees and takes this option. Rule 5, certificate of service indicating this document was mailed to my ex. List of exhibits, benefits details. Exhibit 1. These are probably just the deviations on medical, dental, and vision. And then the premiums that I was paying at the time. Request for submission. If you want to learn more about what this document does, watch my video on the topic request for submission. Basically submitting to the court for consideration the motion seeking leave to set the vision appointment. And what this means is my ex never filed an opposition to this motion either. Rule 5, certificate of service indicating this request for submission was sent to my ex. Next document, we have another request for submission. This is on the renewed motion for order to show cause. You guys would have seen that, I think, 2 videos ago, probably. Anyway, I am just submitting the renewed motion for order to show cause to the court for consideration as well. Again, my ex did not file an opposition to this motion. Rule 5, certificate of service indicating this document was mailed to my ex. That's it. Going into the aftermath, I filed 1, 2, 3, 4, looks like all 5 documents, but they were all free filings, so I incurred $0 in costs. My ex didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex didn't have an attorney either, so she incurred $0 in attorney fees as well. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.